to our motion for summary judgment and filed with the court from William A. McCarter, and he is a representative from American Express National Bank who does have knowledge of the account. And so, Your Honor, this is a breach of contract matter against the defendant, Jolly Abraham. The defendant was extended a line of credit by American Express National Bank. And so they created a contract of which the defendant breached. And there was meeting of the minds of the contract. There was an acceptance, and we have the card member agreement that outlines all the terms of the contract as well. And also it's noted that use of the credit card is also acceptance as well. So the defendant breached this contract by defaulting on their payments to Plaintiff American Express National Bank. And in doing so, Plaintiff has suffered damages as a result of the default in those payments, which is why the plaintiff is here today in court, Your Honor. So in summation, because of this breach of contract matter, the plaintiff has suffered damages in the amount of $37,962.64. So because plaintiff has suffered damages, we are now requesting that the court grant our motion for summary judgment, considering that there is no genuine issue of material fact that the defendant does owe the balance due and owing, and that the defendant did breach the contract.
Thank you, Ms. Haynes. Ms. Abraham, do you have a response?
No.
So all right, and so just out of curiosity, Ms. Abraham, have you had an opportunity to discuss the balance amount with either someone from the plaintiff's attorney's office or someone from the plaintiff's attorney's office? That's the only other person.
I'm sorry, can you say that again, Your Honor?
Sure. Have you had an opportunity to discuss the balance that's owed with anyone from the plaintiff's attorney's office?
No, I have gotten letters of how much I owe. I just cannot pay it.
Okay. Have you contacted anyone from the office to discuss the balance at all?
I want to say in 2019, I contacted them, but when I realized the amount, I couldn't pay it. I think that was the last time I contacted someone.
Okay, and there's never been any attempt to set up any type of payment plan?
No.
Ms. Haynes, or do you have the authority to discuss a possible payment plan with Ms. Abraham at this time?
I do, however, I would have to consult my client for any type of, settlement or any type of offer that she may have as to what she can pay.
No, I understand. I just wanted to just find out if that was a possibility, but I
she's welcome to call the office and possibly we could discuss some type of payment plan, but of course that would have to be after a judgment at this point.
Correct. And so that's what leads to the next thing I'm going to say, which is to grant the plaintiff's motion for summary judgment. I find that there is no genuine issue of material fact. Let's see. Yeah, I find that there is no genuine issue of material fact and the plaintiff is entitled to judgment as a matter of law. So I will sign this order that the plaintiff has filed.
Thank you, Your Honor.
You're welcome. But Ms. Abraham, I will encourage you to, they have the judgment now. They have options on how they can carry out that judgment. And I would strongly encourage you to contact the plaintiff's attorney's office using any of the contact information and any of the letters that you've received, and try and make some attempts to try to work something out. Whether it's a settlement amount or a payment plan of some sort. I'm fairly familiar with the practice, and they we'll set up a payment plan, that will work for you. So I would just encourage you to do that. And just offer you that little, it's not really legal advice, it's just kind of practical advice in this situation.
Can you tell me what the judgment means?
I'm ruling that the plaintiff, which is American Express National Bank, can recover from you principal damages in the amount of $37,962.64 minus any payments that are received after they filed the petition.
Okay.
And also all costs of the proceeding, which is like basically court costs, which is like the amount to file the petition.
Okay.
So this judgment, I'm just reading from the order that I'm going to sign. The judgment also disposes of all parties and all claims, and it is appealable.
Okay.
So that judgment that I'm getting ready to sign will be available in the court's public records if you want to look at it or make a copy of it for your own review. And I'll sign it this afternoon, and it'll be available electronically probably by tomorrow.
Okay. Thank you.
You're welcome. If there's nothing else, then you are both excused.
Thank you, Your Honor. Have a great day.
You too. Bye-bye. Okay.
Your Honor,
Yes, ma'am.
I just spoke, I'm sorry, I just spoke to the attorney, and he said he is in the hold on. Yeah, I'll tell you what court he's in. He said he is in 152nd Court in Harris County. And that if he has to file his appearance, he said he will.
Yeah, I don't have anything in the file that indicates that. Hold on. Hang on. Yeah,
He
so
was
I
on
don't
there.
have anything in the file that indicates that Mr. Pappas has been is the attorney of record for you. But you said, but I did see him dial in earlier on the Zoom. I saw him in the waiting room earlier. So, and I understand completely the perils of multitasking and attorneys having to juggle many schedules. Mr. Prim is over there smiling because he knows how it goes. Mr. Prim, I certainly want to be respectful of your appearance and certainly want to be respectful of your time in knowing that you have appropriately filed your notice of appearance and done all that you were supposed to do in terms of representation for the plaintiffs. However, if Ms. Kemp is representing that she has hired an attorney and he did in fact log in. I did see him earlier. I want to also provide an opportunity for her attorney to do what he needs to do appropriately for his client. With that in mind, can we reset this for next week and allow for Mr. Pappas to file his notice of appearance, and quite possibly Mr. Prim, for you and Mr. Pappas to discuss the case and any type of resolution that might occur? You're grinning again. What is that?
I don't have a filter. I'm sorry. So I guess, the trick with all this is that attorney for plaintiff, oh no, it's an eviction appeal. So time is of the essence for every moment. I guess the split the difference for me on being able to, and of course, my witness is the property manager, so I don't really have much negotiation position that I can talk about. The only thing that I'd say is a split the difference here is if it's a matter of how much back rent. I have a motion that I filed on Friday that's a default because nobody paid rent into the registry in October. And so I'd say, well, can I have a hearing on my default? Because that's a kind of it's not strictly a clerical matter, but it is in the sense of you check the registry, you go, did you try to pay to the registry? Yes, no. So that would be my, with except for a general like object, but then, take my, accept any movement down the way as a matter of course, but at least to say, can we get a ruling on the default, because that's just clerical.
So I do see, and clarify for me what I'm looking at, because I do see a registry transaction in September of $9,000. What does that represent, if you know?
It's my understanding that that's the $9,000 that she paid to the Justice Court to get the appeal sent up. But in the I have to check Rule 509 or whatever it is in the Justice Court appeals for evictions, says that each month they must pay such and such the registry of the court, and they get a letter from the clerk that says you have to pay. If you don't, the lawyer can request a hearing. And so as soon as that day came, it's the day in the lease that says if it's this day you can request, called the court, nothing new in the registry pending October, requested a default. And so I'd like to see if I can get that default heard. And it's not a default as to necessarily a judgment, but it is a default as to possession because of the lack of payment into the registry that at least clears the bar as far as possession.
But I also see, in addition to your default and the content of the default stating that there was a failure to make that monthly rental payment, I also see that there was an affidavit of inability to pay. Where is that?
Yes,
was that only filed with the lower court? Was that?
Yes. So that's kind of interesting. The affidavit. So whenever the Justice Court rules, they set up an appeal bond, but in eviction cases, they also set an amount of money to be paid to the registry of the court for the purposes of rent. And so pretty much everybody files this affidavit of inability to pay that affects the bond, not the rent. And so they're both bonds, and so they get kind of conflated like that. But the affidavit of inability to pay just says, I can't pay the double bond. Usually it's a double bond or sometimes 10. But, and so that's what their affidavit of inability to pay does, is it says, I don't have to pay double bond, but I still have to pay the rent as it becomes due pursuant to Rule 500.
And that amount, what is the a monthly amount for rent for this property?
$9,000.
Your Honor, if my lawyer could look at what it is, I also put in a counterclaim against that for fixing stuff that was credited to me And I had filed all of those motions, and the attorney looked at it and said that I had a claim because I answered the claim that there is over $9,000 worth of credit that I'm supposed to get, that that Basil, which he representing, is supposed to give me back, which I have all the receipts and everything, and I did submit that along with a timeline. So that's why the attorney wants to come in and have the opportunity to show that during the appeal process, I am entitled to take money off of the amount of what it is during that appeal process. And that's what was promised to me. And I've spent a lot of money, and I submitted it to the courts.
So, and at issue here is possession and back rent.
Correct.
And Ms. Kemp, you still currently reside at the property in question?
Yes, and I have submitted all the receipts that I've paid them every month. But that's why we ended up in the appeals court, because the payments tell you every month what day I paid. And I also paid ahead of time. But we went to court in the same month that they're claiming I didn't pay. And there's a letter telling me not to pay from them.
Okay. All right. So
And I answered it. I answered what he said. Put an answer in.
all right, so I'm looking at the 9,000 registry transaction, and it does not specify what that represents. So I don't know if that was being paid as the monthly rent amount, or hold on. Yeah, no, I don't. It doesn't specify. No. Okay, so based on the fact that this appeal came up in September, there was a registry transaction of 9,000. I'm going to deny the default, because I see that there is a registry transaction. If there were no registry transaction at all, it would be a no-brainer for me. I would definitely grant your motion for default, but there is a registry transaction. It's just the money's there. I don't know what it represents, but it could represent the monthly amount for rent. So for that reason, I'm going to deny the motion for default. We're also going to reset this case for next Wednesday at 1:30. Oh, wait. It's marked out for some reason. Hold on. So something going on next week. Oh, I think it's just because there's nothing there. Okay. Okay. So we're going to do a reset for next Wednesday at 1:30. Ms. Kemp, you need to tell Mr. Pappas that he needs to file a notice of appearance at the court. And more importantly, he needs to contact Mr. Prim. It is my hope that Mr. Prim, that you and Mr. Pappas may be able to come to some sort of resolution. You maybe won't be able to solve all of it, but if you can streamline it, and then if you can agree on some things, if you can't agree on some things, I am happy to step in and make a ruling on the things that you can't agree upon. So that's always just my expectation, is that all parties come to me with the things that they absolutely have attempted to work out and are unable to. So that's all I ask, is that there is an attempt.
All right, and do I need to renotice that for the hearing on Wednesday?
No, this serves as notice. And so Ms. Kemp, you won't receive anything, any notice for the next hearing. This is your notice that there will be, that we are basically going to recess. So the case isn't over. This hearing is not over. We're just pausing. So we're going to be in recess until next Wednesday at 1:30. You can use this exact same login. It's a recurring login. So it's the same every single time. Right, Jenica? Wait, did we?
We don't have a recurring Zoom link, so this one's not a recurring. Can you make
Oh.
it recurring? I don't know if that's an option in the settings.
I don't know if I can do it after the fact. Dang it. I thought we made a recurring I said I was going to do a recurring. Okay. All right. Scratch that. Jenica will send you all an email.
Perfect. Awesome.
Okay.
With the login. It may look strangely like the login for today. I'm going to see if I can retroactively make it a recurring Zoom. I don't know if I can do that. So if not, you will get, either way, I'm sorry, that's what I should say. Either way, you will receive login information for next week's Zoom at 1:30. And I
Thank you.
promise it will actually start at 1:30 because, yeah. Okay.
Thank you, ma'am.
All
Thank
right.
you, Anna.
Okay.
Excuse?
You are all excused. Thank you very much and have a good rest of your day.
You too. See you next
Okay.
week.
Bye.